normative and procedural safeguards to be followed in an inter-country adoption. I am not going to take you out exhaustively through the decision, because most of the guidelines or the safeguards which were because most of the guidelines of the Honorable Supreme Court in the first decision of Lakshmikant Pandey was later incorporated in the Juvenile Justice Act 2015, which is now being followed. But however, few recommendations which are necessary to know the manner in which the Honorable Supreme Court dealt with the issue. The Honorable Supreme Court suggested the central government, the Government of India, to formulate a central clearing house, which is known as the Central Adoption Resource Agency, which is now called the Authority. It was initially an autonomous body without any statutory backing. However, later, in the year 2006, the government gave it a statutory recognition in the 2006 Act. Then the Supreme Court directed that the manner in which a child can be abandoned or relinquished. For example, a child to be relinquished, if it's a legitimate child, the child had to be offered by both his parents. Suppose the child is an illegitimate child, then by the mother. The mother has to execute a surrender deed, a relinquishment deed, before the institution, in the presence of two witnesses, and the document will be valid only after 60 days time. 60 days time is for the mother to reconsider the decision of relinquishment. Suppose the mother feels that the decision taken was a waste, or she does not want to relinquish the child, she can always take back the child and cancel the document. This was the first novel method of relinquishment, which is the first aspect of adoption. With regard to abandoned children, the Supreme Court said that the application has to be made before the Child Welfare, the Juvenile Justice Board, which was then in existence. So a child which is normally found on the streets with no person in need of care and protection of the child, and the child who is found on the streets, or going to be called electronic traders, had to be declared legally free by the Juvenile Justice Board. Then the other thing the Honorable Supreme Court said was that all the institutions where children are placed have to be recognized by the central government as well as by the respective state governments. A license had to be issued. Similarly, foreign nationals who wanted to adopt a child had to first contact an agency in their country, that is a sponsoring agency. The agency had to be recognized by their government as well as the government of India. And then, before the adoptive parents come forward to take the child in adoption, the sponsoring agency has to sponsor their application. And a set of documents had to be made by the adoptive parents, which includes the most magna carta of document is the home study report, which contains the intrinsic details of the family and the bonding, the relationship, the surroundings, properties, etc. In addition to the same, the income certificate, the income documents, the property details, the health certificates, recommendation certificates, undertaken by the parents, etc. And this entire dossier had to be prepared by the prospective adoptive parents and given to the sponsoring agency. The sponsoring agency, after verifying the credentials of the family, would then transmit these papers to the Central Adoption Resource Agency in Delhi. And at the same time, the institution where the child is being brought up, the child care institution or the placement agency, has to also maintain a record of all the children available with them. The sponsoring agency, after getting has to first make an effort to place the child within the country with an Indian family. Only if there are no Indian families available can they then process the dossier of the child for a foreign adoption. So the placement agency has to then prepare a child study report containing the exhaustive details of the child and a medical report containing the medical details of the child. Then this child study report and medical report will have to be forwarded to the foreign agency, who will do the matching of the child with the adoptive parents. Once the process of matching is over, the papers of the entire dossier is sent to the country and before to the concerned institution with the power of attorney authorizing the official of the institution to process the case before the concerned court. Now, the issue arose, that is whether since the adoption was not, though we loosely use the term adoption, the foreign nationals were not governed by any statutory backing. So the Honorable Supreme Court said that in order to ensure that the child gets interstate succession rights over the properties of the family, the courts in India have to first appoint the foreign nationals as the legal guardians of the child, and with a rider that they should take the child to the with permission to take the child to their country and then adopt the child as per the laws of their country. So then, within a period of 2 years, the family, after getting themselves appointed as the legal guardians, takes the child to their country with the permission of the court and then adopts the child as per the laws of their country. So, virtually the Honorable Supreme Court has found out a way or devised a means by which, though there was no adoption laws in the country, the child was permitted to be taken abroad and adopted as per the laws of their country. In a way, the child became the biological child of the adoptive parents. If you all know, as you all know, that under the Hindu Adoption and Maintenance Act, adoption, the effect of adoption is defined under Section 12. It says it's a complete transplantation of the child from his family of birth to his adoptive family. So this was the same definition is worldwide, and the child becomes the child of the biological the adoptive parents. So in a way, this was the manner in which it was done, and to ensure that the follow-up is there of the child who is taken abroad, the Honorable Supreme Court held that the adoptive parents should send progress reports pertaining to the child quarterly, that is 4 reports for the first 2 years and half-yearly for the next 3 years till the adoption is finalized. Because once the adoption is finalized, then the child becomes a citizen of that country, and there is no further control that is required. And it is the legislations of that particular country that governs the welfare of the child. So this was the manner in which the Honorable Supreme Court ensured that the welfare of the child is secure. And also, the Honorable Supreme Court in Lakshmikant Pandey 1 also fixed a time frame within which the proceedings had to be formulated by the court, finalized by the courts. Honorable Supreme Court initially said 90 days from the date the application is filed in court. The court has to pass an order. Because as you see, that's why I took you to Shobha's case initially. The first case which was there in the country took nearly 2 years. And in different parts, especially in the north, there were cases which were pending for nearly 5 years. If you go through Lakshmikant Pandey, you can see Justice Bhagavati discussing about it, that there was a huge delay in disposal. So the Honorable Supreme Court fixed the time period for 90 days. Subsequently, the Honorable Supreme Court in the modification judgment reduced the time period to 60 days. That is the law of the land as of now, which is in the JJ Act as well as in the High Court Surplus. There is 60 days from the date of presentation of the petition. The family courts, at that point of time there were no family courts, but presently the family courts have to dispose of an application file within 60 days. Another thing that had to be ensured was the entire records, because it's a very confidential document, especially the relinquishment deed, the details of the mother who has abandoned the child, and also the child's roots, etc., had to be maintained confidential. So the Honorable Supreme Court held that the entire records of the case had to be sealed and securely safeguarded in the court. Another thing which was visualized by the Honorable Supreme Court was, under the procedure on the Guardian and Wards Act, in addition to the respondent contesting respondents, we also normally direct that the notice of the case has to be published in the newspapers. So any person who is affected by the appointment has to also be made a party. Now the Honorable Supreme Court has categorically directed that in the case of an inter-country adoption, the notice of publication regarding the filing of the case shall not be published. It has been dispensed. Another thing was, in order to devise a means for the parents not to come from abroad and wait here or have the agony of waiting here for the entire process, the Honorable Supreme Court held that the parents only need to send a power of attorney in favor of the institution where the child is being brought up. The power of attorney holder represents the adoptive parents, files the petition, gets the petitioners appointed as the legal guardians, and only at the last process, after the passport and the visa of the child is processed, the parents do come down and then take the child abroad. So the Supreme Court found out a way in which the parents need not be troubled. Another thing was, the last part is that as per the Guardian and Wards Act, you find that in order to secure the adoption, we sometimes insist on cash security or property security so that the parents adhere to the conditions imposed by the court. The Honorable Supreme Court held that in the case of inter-country adoptions, there is only need for execution of a bond, which is more than sufficient. Now, these are the general, the outline of the decision. Others, those who want to go more into detail, can kindly go through the decision. Now, I would say that the farsightedness of Justice P. N. Bhagwati, the Honorable Supreme Court, in the decision, has safeguarded the welfare and interest of numerous children of our country, because the dream of having a unified civil code for adoptions took nearly 30 years. It came out only in 2015, and the judgment was rendered way back in 1984. And you can just imagine the anarchy that would have been if there was no law to regulate the adoption process, if not for the decision of Lakshmi Government. So the Honorable Supreme Court came out with the means of securing the numerous children that were taken by the foreign nationals from India to their land by way of inter-country adoption. Now, during this period, the central government had the Children's Act 1969, which was not applicable to the states. It was only applicable to the union territories of the central government. The Supreme Court in Sheila Basi and others versus Union of India, 1986, 3 SCC 632. I have not put it on the screen because it's not of much relevance, but those of you who are interested can read it. Sheila Basi and others versus Union of India and others, 1986, 3 SCC 632. Directed the state governments to implement vigorously the provisions of the Children's Act in the various states. This was because India became a signatory to the United Nations Standard Minimum Rules, which is commonly known as the Beijing Rules. And as a result of being a signatory and to the International Convention, the Juvenile Justice Act 1986 was enacted by the Government of India. Now this act had nothing to do with the second part of the present enactment, that is children in need of care and protection. It was more to do with the children in conflict with the law, which you are all very much aware of. That is the juvenile children who commit offences and how it has to be dealt with. And the act came into force, and the earlier Children's Act, which was prevalent in different parts of the states, were all repealed, and only the Juvenile Justice Act 1986 was there. Now, coming back to the Honorable Supreme Court, the Supreme Court, after receiving the feedbacks from the various stakeholders as well as with regard to the working of Lakshmikant Pandey 1, then came out with the modification judgments. That is Lakshmikant Pandey 2, that is AR 1986. you to the two citations before I go further. This is the second decision, modification decision, that is AR 1986 SC 272. That is the modification made to the normative and procedural safeguards of Lakshmikant Pandey 1. Then, I will take you to the next citation also before I start again. The next decision was in the next year, that is AR 1987 Supreme Court 232. Lakshmikant Pandey versus Union of India, which we call as Lakshmikant Pandey 3. Stop here. In the subsequent two modification judgments, the Honorable Supreme Court held that because it had said that the placement agencies, before placing the child in adoption to foreign nationals, had to make efforts to place the child within the country. The Honorable Supreme Court held that any adoption or any guardianship petition filed in the country, also these guidelines were made applicable. So therefore, by the Lakshmikant Pandey 2 and Lakshmikant Pandey 3, the guidelines formulated by the Supreme Court became applicable to adoptions within the country also, which we call in-country adoption. The adoptions by foreign nationals are called inter-country adoptions. So by virtue of Article 141 of the Constitution of India, the Lakshmikant Pandey 1, 2 and 3 became the law of the land, and all the courts were governed by the decisions. So any adoption, which we lucidly call as adoption, or guardianship appointment made within the country, the courts were bound to follow the directions in these three decisions. Now, at this point of time again, there was the United Nations Convention of Human Rights on the rights of child to be adopted. This came into force on 2/9/1990. The United Nations defined a child as a human being below the age of 18 years. India was also a signatory to this said convention, and the convention left it to the discretion of all the stakeholder countries to put the age of the child anything below 18, but not above 18. India accepted the general law as per our municipal laws that a child is somebody who is below the age of 18 years. On the basis of the said convention, we had the first juvenile justice. After the Juvenile Justice Act, the second act came into force, that is the Juvenile Justice Care and Protection of Children Act 2000. This was the first act where the second part of the present Juvenile Justice Act is there, that is children in need of care and protection. In addition to the children in conflict with law, the next part is the children in need of care and protection. So this was the first concept where the children who were found abandoned and relinquished were brought within the fold of a statutory law other than what Lakshmikant Pandey laid down. Now, as you all know, there was a very strong resistance from certain sectors of the communities who said that this is going to be a backdoor entry to a unified civil code which was lying fossil under Article 44 of the Constitution. So there was resistance, and you all also know there were three bills that were introduced called the adoption bills in the Parliament. but all the three bills fizzled out and it did not become a reality. And finally, it was through this way that through the Juvenile Justice Care and Protection Act 2000, that enactment for catering to the welfare of the children in need of care and protection was brought in. Now, as you are very well aware, people find out means and ways to come out or circumvent the directions or a law that is in force. Now, Juvenile Justice, the Lakshmikant Pandey 1, 2 and 3 only went on to say that children who are found abandoned and relinquished are governed by the guidelines. So what the persons, the middlemen in the field, what they found out was foreign nationals started approaching adoptive, the biological parents directly without going to an institution. Now again this started causing a mischief in the country because people started indulging in malpractices and offering money more like a surrogate child-mother relationship where a foreign national approach a lady who was found having an illegitimate child and pay her a ransom and take the child and go out of the country. Now this again became a problem in the country, and in the first decision subsequent to Lakshmikant Pandey, it's known as Anoka versus State of Rajasthan and others. I will take you to the citation. Yes. That is 2004 1 SCC 382, Anoka versus State of Rajasthan and others, where the Honorable Supreme Court held that a child given in adoption by its biological parent to a foreign couple need not follow the guidelines prescribed for adoption of Indian children. Now, this gave a lot of leeway to the middlemen who felt that Lakshmikant Pandey or the stringent guidelines formulated by the Honorable Supreme Court in Lakshmikant Pandey can be bypassed by approaching the adoptive parent, the biological parents or the biological mother directly and take a child outside. So, in order to get over this, in a subsequent decision, the Honorable Supreme Court, that is in St. Teresa's Tender Loving Care Homes and others versus State of Andhra Pradesh, 2005 8 SCC 525, came out with a subsequent decision and said, in order to prevent child trafficking of children and to promote the welfare of the children, you have to strictly adhere to the guidelines laid down in Lakshmikant Pandey 1, 2 and 3. Now, in the meantime, there was a 2006 amendment which came into the Juvenile Justice Act, by the Juvenile Justice Act. Then, in the 2006 amendment, it was actually brought in to get over Anoka's case because there were a lot of people, a lot of courts who were following the decision of Anoka because it is the same co-equivalent bench of the Honorable Supreme Court, both Lakshmikant Pandey as well as Anoka, and also in St. Teresa's Tender Loving Care's decision. So few courts continue to ratify the direct adoption by foreign nationals from the adoptive parent, from the biological parents. Then the Supreme Court, the central government came out with the Juvenile Justice Care and Protection of Children Act, Amendment Act in 2006. It was for the first time that the central government said that the adoptions in the country, inter-country adoptions in the country would be guided or would be has to be followed as per the guidelines to be formulated by the CARA or the Central Adoption Resource Agency, which is the statutory authority. And the Central Adoption Resource Agency came with the guidelines of 2006 for inter-country adoptions and in 2008 for in-country adoptions. I am not taking you all to all these things because this is just the background of the history of the enactments which were there. But for the decisions you should go through them because it is relevant and you will get some insight of how the ways and means the Supreme Court dealt with the issue. Now, the the court started facing a problem because under the Supreme Court guideline, the Supreme Court, Lakshmikant Pandey 1, 2 and 3, the Supreme Court said the documents that were executed by the foreign couple abroad had to be first notarized and then Indian embassy attested. We have to take it to the Indian embassy and attest it and then send to India before to be they are accepted by the court, because the court only looks into the Indian embassy attestation as it is considered, only then it is considered to be a genuine document. Now, in the meantime, what happened was India became a signatory to the Hague Convention. Hague Convention had a specific means to get over this problem of attestation of documents. Attestation of documents as per the Hague Convention is the foreign ministry of each country attests the document. You need not go to the Indian embassy or Indian consulate in the foreign state. For example, I would put it in another way. Suppose a document is executed in India and has to be used in a foreign country. Earlier we have to suppose you have to use it in the United States of America. You have to first get it notarized, then take it to the Home Department, and then take it to the US Embassy to get it authenticated or legalized. But after the Hague Convention came into force, the manner in which the document is legalized is we first get it attested by a notary public and then take it to the Indian Home Ministry in New Delhi. Once the document is apostolic stamped by the Indian government, that is by the foreign ministry, then this is universally applicable to all the signatory states. Now, since the Honorable Supreme Court had held you have to follow the earlier route of attestation, the Honorable Supreme Court came out with the fourth part of the Lakshmikant Pandey's decision, that is Lakshmikant Pandey versus Union of India, which we call Lakshmikant Pandey 4. That is that is 2010 12 SCC 735. 2010 12 SCC 735. This again was a modification of the Lakshmikant Pandey 1, and the Honorable Supreme Court held all the documents which were executed abroad can be authenticated as per the guidelines laid down in the 8th Convention of Hague with an apostolic stamp. You should read the decision because as judges, before various courts you may get foreign documents seeing this stamp. Being a practicing lawyer, I have faced the difficulty where the judges have asked, how can a stamp which has been attested by a foreign country be believed to be genuine? Now, in view of being a signatory to an international convention, the Indian government has accepted and ratified this mode of attestation, which has to be accepted. That is the apostolic stamp. So don't get perturbed on seeing a document which is bearing an apostolic stamp. Then another thing which the Honorable Supreme Court held was that children had to be first placed in adoption within the country. But children of special needs, children with medical problems, children with physical and mental disabilities who are normally not adopted in the country or taken in guardianship in the country can immediately be offered for adoption to foreign nationals. So again, people started finding out a loophole in getting over this, making use of the situation. So what they started doing is they started branding or labeling all the children with serious medical problems, So they started fabricating documents, medical reports, saying that the child has a serious medical problem and no Indian family would come forward to take the child in adoption. Then the Supreme Court came out with a decision in Craig Allen Courts was a state and another. That is 2010 8 SCC 794. Supreme Court directed that the Central Adoption Resource Agency to constitute an expert committee consisting of a panel of